Tristan Sullivan-Leppa. She is the section manager with the Office of Legal Affairs, which is also part of the SEBB Appeals Unit. Zachary Robinson, who is the staff attorney with the Office of Legal Affairs, which is also part of the SEBB Appeals Unit. And then lastly, we have Tracy Coleman, who is a Program Specialist 3 with the Outreach and Training Department, and she is also our SME when it comes to PEB and SEBB error corrections. So with that being said, I'm going to go ahead and turn it over to Tristan.
Thank you, and good morning, everyone. Okay, we're going to start out by pointing out some important dates to remember. October 26th was the start of the SEBB annual open enrollment period for the 2021 plan year. November 23rd is the last day to enroll or make changes to an account for the 2021 plan year. And January 1st, 2021, it marks the date for the new plan year to begin. New elections made during the annual open enrollment are effective as of January 1st, 2021. Okay, so these enrollment windows listed on the slide are important. A lot of appeals come from employees missing these deadlines. Missing these deadlines can have harsh consequences for employees and their families. For example, missing an initial enrollment window results in someone being defaulted into benefits, and missing other enrollment windows oftentimes means that a dependent cannot be enrolled onto someone's benefits until the next plan year. An initial enrollment window, with regards to initial enrollment window, it is very important to remember that the deadline is 31 days from when an employee becomes eligible for the employer contribution, which is usually when the employee starts work, not necessarily when they've received the eligibility notice. Annual open enrollment is 1 month, usually in the fall, and during this enrollment window, you can make changes to your benefits for the following plan year. Special open enrollment events are typically 60 days following a life event such as marriage, divorce, or birth of a child, allowing for certain changes to be made for an account mid-plan year. If you have questions about what changes can be made during a special open enrollment event, please reference SEBB Policy 45-2A, which is available on the website and linked on this slide. Okay, when a subscriber is denied by the SEBB program, the program will send a letter that contains appeal rights to the subscriber. Subscribers who receive program decisions should appeal directly to the SEBB Appeals Unit and do not need to use the appeal form or have the program decision reviewed by their employer. If you receive questions from an employee about a program decision that they received, please encourage your employee to follow the instructions on the letter regarding how to file an appeal. Please also remind them to include any relevant documents and to pay close attention to the deadlines on that letter. Again, a SEBB organization does not need to review or make a decision on appeals that have, on program decision letters. Okay, on the other hand, when there has not been a program decision letter issued, it is the employer's responsibility to review the employee's request and make the initial decision before the appeal is sent by the employee to the SEBB Appeals Unit. The appeal form is found on the SEBB Appeal website and is used for when a SEBB organization is to issue a decision. We will explain later in this presentation where to find the appeal form, and also we'll be going through the different steps of the appeal form. Washington Administrative Code 182.32, 2010, and 2020 give employees the right to appeal eligibility and enrollment decisions or denials made by their SEBB organization. Okay, next slide. Washington Administrative Code 182-31-030 explain various responsibilities that all SEBB organizations must carry out. This includes, but is not limited to, all actions, policies, and guidance issued by the SEBB program, which are necessary for the operation of the appeals process. SEBB outreach and training staff are available for guidance, but are not available for decision-making. We encourage all SEBB organization staff who are involved in the SEBB appeals process to review the applicable Washington Administrative Code the revised Code of Washington, and the program policies all linked on this slide. Now we are going to talk about the appeal process, starting with the employer decision and how to use the appeal form. When an employee has a request regarding their eligibility or enrollment in SEBB benefits, their request is sent to the SEBB organization for review. If the employer is unable to make the requested change, the employer should direct the employee to the appeal form. The cover page on the appeal form explains 3 different situations. Situation number one describes if an employee disagrees with a decision made by their employer or agrees that further review is needed because the employer believes that there was an error. It directs the employee to fill out sections 1 through 3 of the appeal form and submit it back to you, their benefits administrator, for another review. It also explains the next step in the appeal process, which we'll go into more depth in the coming slides. Situation number 2 describes the situation we spoke about a few slides ago when an employee, or when a SEBB program makes a decision. While this form can be used to file an appeal in that situation, it is not required as the employer does not need to review a program decision. An employee can submit a written document or letter directly to the appeals unit in response to a program decision. Situation number 3, which is not pictured here on this slide, describes when an employee wants to appeal a decision by their SEBB health plan or insurance carrier. We will discuss those later in this presentation. Please note that we have not completed all of the updates for the 2021 appeal form. It is important for employees to use the updated appeal form that is found on the website. Occasionally, we will update the appeal form mid-year. This is a really good reason as to why it's important to not save a copy of the appeal forms to your computers and encourage the employees to access the appeals website for the most current version of the form. We are going to make updates to the SEBB program decision portions of this form to bring more clarity to the situation. Now we are going to walk through the appeal form and how it works. Next, assuming the appeal relates to situation number 1 on the cover sheet and the employer decision is needed, the employee will complete sections 1 through 3 of the appeal form and send it to their employer for another review. It is important that the employee is the one filling out these sections on the appeal form, not the employer. Section 1 of the form is information about the person filing the appeal and information, let me start over here. Section 1 of the form is information about the person filing the appeal. It is helpful to the appeals process if we know who is making the appeal, a subscriber, an applicant, or a dependent. A couple things to note here are a primary account holder is also known as a subscriber. An applicant who is not currently enrolled also includes someone who is determined to not be eligible, meaning they're not currently enrolled in benefits because they're not eligible. And a dependent of an employee is a spouse or a child. Please note the term appellant that we will use in this webinar is describing the person who filed the appeal. Also in section 1 is a space to fill out information on dependents involved in the appeal request. This section is important to fill out, especially if the appeal has to do with specific dependents or the family as a whole. For example, if a child was not added, this page is added to someone's benefits. This is a great place to put down that child's information that the person is appealing about. It is not needed to list all of the dependents on a subscriber's account. It's only for people relevant to the appeal. Providing this information is useful in processing the appeal. Okay, so sections 2 and 3. Please make sure that the employees fill out both sections 2 and 3 of the form before they send the appeal form back to you for your employer review. Section 2 needs to be filled out to indicate what exactly the employee is appealing or asking for. Some examples of reasons to appeal are wanting to change medical plans or dental plans, or adding and removing dependents, or wanting to waive enrollment. If this section is not completed, it will cause delay in an order being issued. We need to know what the appellant is asking for before we can process an appeal. Appellants should be encouraged to go into as much detail as possible and submit any supporting documentations that they have with their appeal. We oftentimes see appellants attach letters to this form if they cannot fit their request in this box. Once an employee has filled out sections 1 through 3 of the form, they need to send that form to you, their benefits administrator, to review the request again. And it will be your responsibility to fill out and complete sections 4 through 6 as applicable on this form. Next slide. Okay, section 4 is for the employer to complete, and this section spans over 2 pages. It is important, that is an important thing to note, because a lot of the times we'll see employers miss that second page. This part of section 4 allows the benefits administrator reviewing the appeal to provide their contact information. This information is very important, as we will oftentimes reach out to the employer for additional information on an appeal. At the start of section 4, it also provides directions for what an employer needs to do in sections 5 and 6. Section 5 pertains to the error correction process, which will be explained here in a few slides later in this presentation. And section 6 is the employer signature. The date circled here is an important procedural date that needs to be completed by the employer. Step 4 continues on to this next page. You will need to provide the date when the employer decision was made, as this date is used when the SEBB appeals unit determines if the employee's appeal was received timely by the SEBB appeals unit. Additionally, the last part of section 4 is where you mark your decision. Make sure that you are providing both the date of when it was received and actually marking your decision. If you decide that an incorrect decision has been made where you feel that there has been an error, you will need to mark that box and move on to section 5. One question we received was, what happens if a benefits administrator does not mark the employer decision on the appeal form? If no employer decision is marked, this will cause delay in processing your employee's appeal, as we will have to reach out and contact you for your decision before the appeal will be processed. When an employee does not send the form to their employer first, then we will send the employee a letter telling them that their appeal is premature and needs to be reviewed by their employer first. Obviously, this does not apply if there was a SEBB program decision issued, as we discussed in previous slides, where the employer decision is not necessary. Now, Tracy will walk you through sections 5 of the error correction process. Thank you.
Good morning, this is Tracy, and when an employer sees that they may have made an error on the employee's account, it's important to note what type of error occurred and whether it falls under the error correction process. And that's determined by WAC 182-3060 and policy 11-3. There are 6 areas in which error correction that the employer has to follow this process, that it'll be an error correction rather than being sent on as an appeal to the Office of Legal Affairs. The first one, A, is failure to provide notice to an employee, and the information, and it's spelled out in policy 11-1 and also in the WAC. The second one, B, is a failure to enroll the employee. This is the one that if you've forgotten a dependent, if there was a supporting documentation and the DV didn't get put on the account, or the employee had a SOE and they were trying to add a dependent to dental coverage because they lost other coverage throughout the year. This would be pretty much anything that would be manually input by a benefit administrator where there was an action taken that resulted in enrollment not occurring as it was elected by the employee. Next slide. Which is different than number C, or letter C, which is when the employee fails to take action on the account and does not submit or complete the enrollment forms or enrollment in SEBB my account. And so when that happens and it's not timely, then there is an instance when the BA may not actually enter the default enrollment into the system. And see, this is what we're referring to. It most often happens that I see an error correction when an employee perhaps wants to waive their coverage, or they become eligible late in the year and they're already on their spouse or domestic partner's other employer coverage, and they don't even want the benefits. But in actuality, it's a requirement that they're entered into the system if they're eligible for benefits and they've become eligible for the employee contribution. The next one, D, is the failure to reflect an employee's premium surcharge attestation or spousal attestation. So this happens often when if the employee turns in a form rather than completing the attestation in the system. So it's just really important to make sure that that correction is done accurately, and so that the employee is not being charged for any, additional premium surcharge that they should not be. The next one is when an employee is sent over as eligible. Perhaps they were allowed to enroll. Perhaps they default into coverage, but the employee actually is not eligible for benefits. Either they didn't start work, you thought they were starting at the beginning of the school year or during this initial enrollment back January, and they've been on coverage for a length of time. And when you're reconciling the invoices for your employees, you realize that this employee is not actually enrolled, or they are enrolled, but they're not even working for your school district. This is really a sticky one in that coverage is not rescinded, and the employer is expected to keep accurate eligibility records. And so the coverage is actually prospectively terminated without rescinding the coverage, and the employee is not responsible for the premiums. So it's a really important one to make sure that you're reconciling your accounts and keeping track of your eligibility of employees, because it can be very costly to a school district. And then the last one has been added in the last couple of years for PEB and for SEBB, and that's when BA or whoever's talking to the employees regarding benefits, and they actually misrepresent information or rules or eligibility that the employee relies upon. And it can sometimes result in the employee missing a deadline or not submitting the correct documentation, which affects their enrollment. And so when that happens with any of these, if it goes beyond a certain length of time and this employee brings this review to your notice, these are the items that when you're doing the review, you're going to want to reflect and see if they fall in these categories. And these are the areas that you would submit through outreach and training with the form for error correction. Next slide. So the biggest thing is BAs, school districts, sub-organizations are expected to enroll the employees as described. You're expected to reconcile the payments as needed in the account correction, and then also make sure that the employee is aware and given notification that they have recourse options, which are listed in Section 5 of the WAC 182.30.60, which can result in the employee requesting premium payments being made. They can ask for claims. They can ask for payment of other insurance that they've maintained because they didn't know they were eligible for these benefits, and it costs them more. The employee actually has opportunity to be made whole through this error correction and recourse process. And so the most important thing is when you run across an account in this review process, if you see that there is something that needs to be corrected at school district level, that you send the information through FUSE to outreach and training so that we can get the error correction process rolling and get the account corrected for the employee, and also so that you can correct the account and move on with your day. So part of the determining whether it qualifies for error correction has to do with whether or not it's within a lower limit. Accounts, you may still have to send it into outreach and training, but the additional process of notifying the employee, allowing for them the opportunity to request recourse, and then correcting the account, that's error correction process. But if the error occurred within the lower limit, which is generally within the last 3 months, then it's just correcting the account. However, it's really important to note when the employee brings this error to your attention that if it goes beyond the lower limit, that it's beyond the accounting lower limit and billing, that it'll have to be handled through the error correction process and follow specific notification, correction, and recourse allotted for the employee. So when the error correction comes into outreach and training, either the legal team or outreach and training staff will determine whether or not it fits as well under that category. And that's where it'll be decided whether or not it's important to get that determination, so that if in fact it does not fall under the error correction process, that then the employee has the opportunity to send the appeal on to Office of Legal Affairs, submit to SEBB appeals for the next step. And here's a scenario that can occur. A lot of times these don't come in with that formal, employee request for review, but an employee who is eligible in March completes the enrollment and hands, dependent verification to the benefit administrator. And then in August, they realize that they haven't received a card for their spouse or one of their children. And so they go to their BA and check, and the BA determines that it's still pending. And then they look through their paperwork or with one of their coworkers and find out that dependent verification document is still sitting on a desk or has not been uploaded and verified in the account. And so when that happens, if it's within the lower limit, the BA can go ahead and just verify the account. They may have to send it in to have the dates updated through outreach and training, but that's the end of the process. However, if it goes beyond the 3 months, then the employee, the correction will be prospective, but the employee has the right to request retroactive enrollment for that employee and notice and correction and recourse. So the biggest thing that I would like for everyone to walk away from is to be familiar with the 6 areas that fall under error correction, and then that the form itself would be needed to send into outreach and training through Fuse rather than faxing it to SEBB appeals, so that it can expedite the correct next process. So in summary, if an error occurs, the BA recognizes the enrollment errors and fills out section 4 and 5 of the form. It's really important that a separate person, not the one making the review, actually reviews the form as well and signs off as a third independent person. And then the next step is that the form actually needs to be sent in for final determination by outreach and training, so that we can make sure that we can actually handle it under the error correction process. And again, this is the most important information. The employer needs to sign their name, and put your contact phone number on there. There isn't really a space for email, but that, especially during COVID time, it can be important as well. Oftentimes it's easier to get a hold of folks through their email, but we do have access to, if we can find your name and information.
All right, thanks, Tracy. I'll take it back over from here.
Okay.
And I believe there is a place for the employer's email address back in the first part of section 4. But okay, so section 6 is where the employer needs to sign the appeal form. And once the employer signs this section, they need to turn the form back over to the appellant, also known as the employee usually. The employer should keep a copy of this form for their records and direct the employees to fill out sections 7 through 9 and continue with the appeals process. So the employee's appeal needs to be received by the healthcare authority within 30 days of the date that you made your decision. The date that you made the decision, as a reminder, is again on section 4, page 5 of the appeal that we spoke about on a previous slide. Appeals are considered to be timely if we have received the appeal by the 30th day following the employer's response. If the appeal is received by the healthcare authority after 30 days, it is considered untimely and will not be processed. The employee will be mailed a letter that informs them that their appeal was determined to be untimely. Okay, next slide. All right, so section 7 is for the employee to explain why they disagree with the employer's decision and add any additional information as to what they are asking for with regards to their appeal. Again, employees, also appellants, are encouraged to go into as much detail as possible and submit supporting documentation that they may have with their appeal. Section number 8 is an optional section if somebody has another person representing them. A representative could be an attorney, but does not have to be an attorney. If the employee has a representative, they can provide that person's information here. We will also need to have documentation such as a power of attorney or a release of information on file in order for us to engage in correspondence with that representative. On the right-hand side of the slide is where the release for information can be found on the appeals website. It's important to note that a representative cannot be an employee of a SEBB organization or the healthcare authority. Okay, so section 9 is the appellant's signature section. This section is where the appellant needs to sign the form and follow the steps as to where to submit this form on the bottom of this page if they wish to continue with the appeal and file their appeal with the appeals unit. We do not have a way to accept appeals via email at this time. We hope to have an option like this or an online portal at some point in the future. It is important to remember or to remind you as benefits administrators to not send the appeal through the Fuse system. It is the employee's responsibility to submit the appeal per the methods prescribed on this form. I would like to take a minute to note that we have recently updated this appeal form to allow for an option for employees to opt in for the healthcare authority to send appeal decisions to the appellants through email. In order for the appeals unit to send an appellant an order via email, the appellant must complete that part of section 9 as shown on the slide by checking the box and writing their email address on this form. This option is now currently being added to program decision letters as well. Once an appeal has been received and opened by the SEBB appeals unit, an acknowledgement letter is sent to the appellant. This letter will state that the appeal has been received and that the SEBB appeals unit will have 10 business days to issue a decision unless a continuance is granted. If a continuance is granted, they will be also notified of that continuance and the new date for which an order would be issued. Now Zach will talk about the authority of the presiding officers, how to read an initial order, and a further explanation on the next steps in the appeals process, also known as the request for review process. Thank you.
Thank you, Tristan. The presiding officer is required by rule to decide the issues of the case based on the information provided by the parties and the evidence provided by the parties. The presiding officer is required to apply the Washington Administrative Codes and policies as the first rule of law, meaning they do not have the authority to disregard a rule as invalid or unenforceable. One question we receive often from a SEBB organization was if the BA approved the change requested by the employee in their appeal, why was the appeal denied by the HCA's presiding officer in the initial order? A presiding officer looks at the brief adjudicative proceeding file, which is comprised of documents from the program, the employer, and the employee, as well as the applicable WACs and program policies to determine its decision. Next slide. The SEBB unit will send and request documentation and information from the SEBB organization. When gathering evidence and information to add to the BAP file, they will reach out to the SEBB organization to request this. The SEBB organization is required under WAC 182.32/2020 2A2 to respond within 2 business days and provide the requested material to the SEBB appeals unit and the appellant. Once these materials are added to the brief adjudicative proceeding file, they will be reviewed by the presiding officer, and the presiding officer will issue a written initial order within 10 business days of receiving the requested notice of appeal. It is important to note, though, that a continuance can be granted at any time for up to a length of 30 days. And next slide. What is the submission of documents order? So from time to time, the presiding officer may request additional information from either the appellant, the SEBB organization, or the SEBB program. And to do this, the presiding officer issues a submission of documents order, which requests the additional information and documentation and a deadline for when the documents must be received by. If no documents are received, then the presiding officer would be required to make a decision based on what information was available, and that may lead to unfavorable results. Oftentimes the hold on a second, just go back to that slide for just a second. Oftentimes a continuance is usually included with the submission of documents order, which would allow time for the information to be sent to the SEBB appeals unit. Again, a reminder that the WAC requires that the SEBB organization responds to the submission of documents order within 2 business days, whenever possible. Next slide. So the presiding officer or the review officer may convert a brief adjudicative proceeding to a formal administrative hearing, usually when it involves a question of fact. And what does this mean and what will happen? So what this means is that then a notice of hearing from the Board of Appeals will be sent out to the appellant and to the SEBB program, which will contain the location, the time of the hearing, and login information for the hearing. This notice will also contain deadlines for submission of additional information or documents for consideration by the formal hearing officer. The hearings are held by telephone, and they are usually scheduled for an hour, but could extend longer if more time is needed. The SEBB program may call witnesses or request declarations from the business administrators of the SEBB organizations. It really depends on the issue at the hearing, but if a BA is called, generally the questions for the hearing will involve your history, what training you have, what the normal work process is, and how you determine eligibility decisions or enrollment decisions, or whatever the issue is that is at the hearing. The employee is allowed to have someone else represent them at the hearing as long as they are not an employee of HCA or its agents, and HCA won't pay for the attorney. A final order from the hearing officer will be sent out. The employer will not get a copy of the final order. Next, we will look at how to read an initial order issued by a presiding officer.
Are you still there, Zach?
Next slide.
Looks like we might have lost Zach.
No, I'm still here.
Oh, okay. Sorry, it went, it paused for quite a while, so I don't know if you were talking in that time. I wasn't able to hear you.
Oh. So now we're looking at reading an initial order.
So Zach, where you left off was the employer will get a copy of the final order. That's where you cut out.
Yep, the next piece is we will look at how to read an initial order issued by a presiding officer. So that's the next section. At the top right of an initial order will contain important case identification numbers. This will have the case number and the appellant's name. The one point under each of the initial orders will be the issue statement, and generally this will summarize the appellant's request that the presiding officer is making a decision upon. The BAP file and the information in section 2 will contain the documents the presiding officer used in order to make their decision. Next slide. Section 3 of the initial order will contain a statement of facts which are relevant to the case. Every fact in this section will have a citation to the BAP file or where that fact came from. And then we use those, next slide, and we use those facts and apply them in section 4 as the conclusions of law. So the laws that are used are all in section 4 are all located online on the Washington State Legislature site. SEBB eligibility and enrollment codes are found in Washington Administrative Code 18230 and 18231. The appeals rules are found in Washington Administrative Code 180, Chapter 182-32. All the laws that are used will be provided after each statement of law. So essentially that they will have a citation as to where that law came from. The presiding officer will provide the rule and then apply the rule to the facts, and then will issue decision based upon that application. Next slide. Finally, in section 5, there will be an order which either affirms or reverses the decision made by the SEBB program or SEBB organization. Next slide. If the presiding officer affirms the decision of the SEBB organization or program, that means that they agree with the original denial. If the decision is overturned in full, then the presiding officer finds that the decision from the SEBB organization or program is incorrect, and the presiding officer will reverse the denial. There is a possibility to have a partial affirmation or partial denial, depending on what the issue is. Next slide. Once the initial order has been issued, an email with a courtesy copy of the order will be sent to the benefit administrator on file for your district. It is important for the school districts, and it's the school district's responsibility to notify outreach and training of any BA staff changes for notifications. And outreach and training will notify the appeals unit of any changes to the contact list the HCA uses. Next slide. If the employee does not agree with the written order, the written initial order, they have 21 calendar days from the date the initial order was issued to request further review by a review officer. This can be written or an oral request from the appellant. Instructions on how to do this will be in the initial order. If a request for review is received after the 21st day, it will be considered untimely, and an untimely letter will be sent to the employee. This must be received in the appeals unit by the 21st day. The appeals unit does not go by the postmark day. Additionally, information on requesting a review of the initial order is included at the end of each order. To request review, the employee must file a written or oral request for review to the SEBB appeals unit. The request for review may be received by mail, fax, or through the telephone number provided. If the appellant requests review of an initial order within 21 days, SEBB review officers will review the decision of the presiding officer to ensure that the correct application of rules to facts was applied. The review officer has similar authority to the presiding officer, where they can issue SODs or submission of documents orders and can issue continuances. The review officer will send a copy of the final order to all the parties. Once a final order is issued, the employee may request judicial review of the final order. To do so, the employee must file a written petition for judicial review following the requirements listed in RCW 34.05.510 through 34.05.598. The SEBB program is not allowed to request judicial review of final orders. Judicial reviews are heard in Superior Court. An appeal cannot be filed in Superior Court until a final order has been issued on an appeal. This is super important. I will repeat that one more time. An appeal cannot be filed in Superior Court until a final order has been issued on an appeal. The next couple of slides will help show where employees can access the appeal forms. Once you're on you're on the Washington State Healthcare Authority homepage, you will click on the school employees link. Next, you'll click on File and Appeal in the How Do I section. Finally, you will click on the link under the box of Who Can Appeal, and that will give you access to the most current appeal form. It is very important that you, again, not save a copy and you retrieve this form from the website because it's updated from time to time. We had mentioned earlier that we were going to talk about when to appeal to your health plan. So more information on when and how to appeal to your medical, dental, or vision plan will be found in your certificate of coverage for those specific plans. If the employee issue involves a claims payment, processing, or reimbursement for services or supplies, or involves a pre-authorization decision, the employee will need to appeal to their specific plan and not to the SEBB appeals unit. More information on how to appeal a health plan's decision can be found in the certificate of coverages. You can find the certificate of coverage on our website, and under the forms and publication section, you need to click on the customer type as school employee, and then the topic is certificate of coverage, and it will have each one specific to the plan that the employee may be appealing. And the final few slides are included for reference and maybe easy printouts to include as to where to look for the rules on how to appeal and for SEBB organizations, SEBB programs, and SEBB health plans. The next slide is a review of the major dates, important dates that we've talked about through this, and I'm not going to go over all of them, but it's important to know the 30 which ones are 30 days, which ones are 10 days, and which ones are 21 days. The next slide is a printout of the entire appeal process and how this works. Again, next slide. The final few slides are resources, outreach and training you can find for guidance. Another reminder about we request that you do not submit appeals through Fuse. Outreach and training via Fuse and the 800 number is for benefit administrators only. Employees should not be given this information. Fuses are for general appeal related questions and requests for status checks as needed on an active appeal. BAs can send their questions regarding SEBB benefits outside of a specific appeal through Fuse. Next slide. The SEBB enrollment guide on pages 73 through 74 has information on the appeals department, and that is our phone number as well. And finally, please don't send appeals. Sorry, next slide. Please do not send appeals through Fuse, but questions are okay. And one final reminder again that the employee is responsible for sending their appeal. And so they can submit that through the fax or mail information listed here. And that is it. I will turn it back over to Sarah. Thank you.
All right, thank you, Zachary. So I just want to thank the three of you, Tristan, Zachary, and Tracy, for helping guide us on the SEBB appeals training, and hopefully it allows UBAs to understand this process a little bit better. To wrap up today's presentation, I just want to give a quick announcement that we are doing a webinar later on here in November. So November 20th, we're going to be doing a webinar on the SEBB data for Form 1095 reporting. So the registration is open. So here's the link to go ahead and get registered. And just a reminder that all past webinars are recorded and posted to the BA website for viewing in the future if you wish. And we want to thank you for participating in today's webinar. Happy Friday, and I hope everyone has a great weekend. We will keep the webinar open for a little bit longer so we can gather any questions that you may have. Like I said at the beginning, we will gather all of the questions that we received today, and we will get back to you, I would say, within probably the next couple of weeks. We'll be able to get those answers out to you via either email, phone, or Fuse. But thank you again, and I hope you have a great weekend.